Broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, Handling Real-World Problems. My name is Anna Hobson and I'll be your moderator today. I work on the marketing team here at hrsimple, as well as the American Chamber of Commerce Resources, and I'm excited to be hosting this session. Before I introduce today's speaker, I have a few housekeeping items to go over. First, today's webinar will be about an hour, and at the end, I will provide SHRM and HRCI codes. If you have any questions, there is a question area in the chat box. Those questions will be answered at the end of the session. If you need to access the webinar again, it will be posted on our site, hrsimple.com. Today's presenter is Stephen. Steve is an associate at Kastner, Westman & Wilkins. KWW authors our Ohio Human Resources Manual. Steve has spent the majority of his career representing employers in workplace matters throughout Northeast Ohio. As a litigator, Steve has defended employers in numerous cases involving allegations of discrimination, harassment, retaliation, whistleblowing, violation of leave, and wage and hour laws. So without further ado, I'd like to kick things off by welcoming our speaker, and over to you, Steve.
Great, thanks, Anna. I appreciate it. So hopefully my screen should be shared with everybody at this point. Anna, has that gone through okay?
Yes, we're able to see the screen.
Perfect. Okay. So, having gone through this and practiced as long as I have, I know that oftentimes we deal with a lot of hypothetical issues on a day-to-day basis, but my clients frequently ask me, well, what are some real-life concerns that you see recur in your practice? So this presentation is going to focus on some of those real-world concerns that my clients have brought to me on numerous occasions, and things that are a little bit more time-sensitive and tricky to handle, and how best to proceed with them. So as everyone on this call knows, companies have a host of potential labor and employment law concerns to manage in the modern workplace. Sometimes there are time-sensitive situations that require quick, creative thinking. So we're going to cover some scenarios here that I've selected. So first, what to do when you find out a new employee has a non-compete agreement. So going through the scenario here, you hire a new sales employee. The individual during the hiring process doesn't say anything about whether there's any restrictions on their ability to join your company. A day after the employee starts, your CEO receives a letter threatening legal action if the company doesn't fire the new employee. Attached to the letter is an agreement containing restrictions on the employee's future employment. So the idea here is the employee's former employer has sent a letter saying, hey, this employee can't come work for you, and here's the agreement that they've signed that prevents them from doing that. So what's the first step? Well, step one is to check out the terms of the agreement itself. What did the employee sign with the prior company? So the first thing that you should do is really do a deep dive into the agreement itself. I'm well versed in these sorts of litigations and sending these sort of what I call a threat letter or cease and desist letter. And at times, if you review the contract against what's alleged in the cease and desist letter, it doesn't necessarily match up. So that would mean that maybe the prior employer is taking too broad of a view of what the agreement actually says. So the sort of questions to ask yourself as you were to look at the agreement: does it actually prevent the employee from working for your company? Is it really a non-compete agreement, or is it just a non-solicitation or non-disclosure agreement? So a non-compete agreement says, hey, you can't work for any competitors within a certain restricted area. A non-solicitation agreement would say, hey, you can't solicit a certain category of customers. A non-disclosure agreement would say, you can't disclose any of our business information. Some agreements have all of those requirements in it. Some agreements have one of those requirements. Some of those agreements may have two. So it's important to understand what are the actual restrictions that the employee has on their ability to work for your company. Oftentimes these agreements are confusing and poorly worded, and the devil sort of is in the details. So I often tell clients, hey, if you get a letter like that, pick up the phone and call your legal counsel at that stage so you can get a true understanding of what does this agreement actually mean. The other thing is this agreement going to be enforceable? I can't tell you how many cases I've seen in my career where a cease and desist letter comes that says, well, this employee is barred from working for any competitor anywhere in the country. Well, unless you're in a very restricted industry, in most states, that's not going to be enforceable. So really keep in mind understanding what the agreement actually means and whether what that agreement is saying is enforceable are the sort of questions that an outside attorney can help you with. So after you've looked at the agreement, the next step is, what did the employee tell you prior to being hired? So as part of the hiring process, I always talk to clients and say, you should at some point confirm that the people you're interviewing have no restrictions on their ability to work for your company. So really the way you can do that, you can have that be a question as part of the interview process. You can have that be an onboarding document that just says, hey, as part of coming to work for you, I agree that I have no restrictions on my ability to work for you. And that does a couple things. One, that brings the issue to the forefront, that it's something that's discussed in the hiring process and you're aware of what the answer is going to be. Two, if you find out after the fact that the employee actually does have restrictions and they didn't tell you about them, that puts the company in a much more defensible position. Because the concern for you as the employer that receives these threat letter is not just that the employee you hired has some sort of restriction, but that by virtue of that employee's conduct, you could get tied to them. So there's called tortious interference type claims, which basically mean that the company took steps to assist the employee in either breaching their contract or misappropriating the prior employer's business information. So building in that question and making sure you have an answer to that is a key part of the hiring process. So one thing to understand, though, is there's a difference between an employee being dishonest and deceptive and them just potentially not remembering that they even have some sort of an agreement. So I always instruct my clients, hey, talk to your people in advance of an offer about whether they have restrictions. And if you get a letter in that was signed 15 years, that has an agreement attached to it that was signed 15 years ago, it may be the sort of thing you give the employee the benefit of the doubt on, that they may not have any recollection of ever signing that. So don't be surprised if you hire somebody and if you get some of this sort of letter, if the employee tells you, hey, I have no idea I ever signed that. It's dated the day I started work at my prior employer, and so I'm just not aware of it. That being said, I have seen multiple instances in my career where an employee's been dishonest. Maybe they understated what their restrictions were. Maybe they said, no contract, and then they own up to the fact that, yes, indeed, they did have some sort of restriction. Sometimes employees in these situations do what I call ostriching, which is they put their head in the sand and hope that they'll never receive the new employer won't receive a threat letter. And a large percentage of the time, you'd be surprised that people just don't send these letters for one reason or another. So, but that being said, if you do find out that an employee has been actively dishonest, that this wasn't that case where they just, neglected to remember signing it or they just didn't have any recollection of it, I advise clients at that point to just terminate the individual. One, at that point, they would have lied to you. Two, you can't trust them. And so if you can't trust them on a matter like that, I don't think you can trust them in front of your customers or clients moving forward. So after you go into the process of what did the employee tell you pre-hire, the next question is, in terms of evaluating your options, you should look at what has the employee done since joining you. So here in this scenario, we have a sales employee. So what I advise customers and clients to do is look at the customers that the employee has been linked to since joining your company and try to determine whether there's overlap with the prior employer. So the classic example would be, hey, I'm a salesperson in a particular industry. At my prior job, I sold to these 5 customers. I'm being hired by this new company because the new company wants to get business from those 5 customers. So they're hiring me for my experience and for my relations. Well, if that's the case and the employee has a non-compete agreement or a non-solicitation agreement at some point, then that puts you in a more difficult position in terms of, hey, can we wall this employee off, or how do we deal with this employee on a going forward basis? The other question is, what discussions do the employee and their supervisor have surrounding what customers they'll be working with? So I can't tell you how many times in these non-compete cases I've seen in the week leading up to a hire or after an employee started, where there's all hands on deck sales meetings, and during those meetings, the client is soliciting feedback from the new employee on prior customers. And hey, what can we do? What sort of insider knowledge do you have about these customers? That's not necessarily wrong, depending on the types of information that's being disclosed. But if there's a non-compete agreement, that's exactly the sort of interest that's protectable. So again, when you have a situation like this, you want to look at, what has the employee done since working for me? The other thing you want to look at is whether the new employee brought information from their prior company. So in 2019, typically what we're talking about is a flash drive, or whether documents have been emailed, or some sort of disk or something like that, or an external hard drive that the new employee could potentially have brought with information from their prior company. So in these sort of cases involving non-compete, non-solicitation, non-disclosure agreements, it very often boils down to, hey, we need to get a forensic consultant to come look at this computer, because as we're looking to defend the company, we need to figure out what this employee may or may not have done. And again, going back to the discussion of the hiring process, a takeaway is, in addition to having the employees sign some sort of affirmation stating, hey, listen, I don't have any restrictions that prevent me from working for you, they should also sign something that says, I don't have any documents or information from my prior company, and I understand that my role with your company won't require me to use any other company's business information. Those are the sort of self-serving representations to include in new hire documents that if we do get into a litigation down the road where we have some sort of bad actor, new employee who, unbeknownst to us, has brought over business information, we can sort of get out of it by saying, look, we didn't want this information. We had the employee sign an affirmation saying this information is not going to be necessary to do their job. So while the employee may have been a bad actor, we as a company were not in any way trying to steal the prior employer's business information. So after looking at what has the employee done, what do the agreements say, and what did they tell you in the pre-hire process, the next step is look at whether potential litigation is worth it. So there's a lot of competing business concerns that have to be evaluated if you get one of these threat letters. So the question that I often ask clients is it worth it for you to protect this employee? So is this employee so valuable to you moving forward that fighting over a non-compete agreement is going to be worth it? You know, no one wants to have to fire a newly hired employee. It's a difficult process to find employees. Presumably you hired this individual because you think that he or she has a good skill set that can be helpful. However, when you're looking down the barrel of a non-compete type of litigation, those are very, very costly types of cases. And not only do they cost a lot of money to attorneys, but they also cost a lot in terms of resources and time that's being used, because you often have key people within the business operations who are having to take large amounts of their day to try to handle these cases and provide information to attorneys and going to depositions and whatnot. And generally, all of this is happening because of the procedural way in a really short time period. So big picture, that means you're looking at, is it worth protecting this employee knowing that over a 90-day period, I could be spending well into 6 figures in attorney's fees plus forensic expert costs, plus the time of some of my key business leaders in defending an employee. The other thing to understand is that on the flip side, if you decide we do want to defend this employee, you want to look at, do we realistically think this employee is going to be booted from their job by the court? And that can be looked at a variety. Depending on your state, it may be unlikely that a court is going to, suspend somebody from employment based on the terms of a non-compete. However, it could be that, somebody's in a one-to-one competitive industry, they're a sophisticated salesperson, and so therefore it makes it more likely that a court is actually going to take action. So looking at that, do we think that we can, push this off and let the employee keep working? The other thing to understand, and I see this frequently as cases go on, and the difficulty is that oftentimes this isn't a consideration at front, because oftentimes if employers receive this sort of letter, they sort of want to circle the wagons around their employee. But the one thing to understand, particularly with sales employees, is that if they are being sued and the company is being sued for their conduct in relation to certain customers, that means everything that's in play is all of the information that these customers have. And the customers themselves become sort of the key witnesses in the litigation. And so now all of a sudden, by virtue of you standing by an employee, it may be a situation where that's resulted in your customers being subpoenaed and your client contacts being subpoenaed. And that's obviously something that customers really don't like to be a part of, and they want to be kept out of. Because regardless of who's right and who's wrong, the customers just sort of decide that they're frustrated with everybody involved, and they may not want to deal with either the companies on either side, and certainly not the employee at issue. So it is a really significant area of sensitivity for, frankly, both sides of the operation when these sort of cases are pursued. So after you've evaluated all of these competing concerns with this employee who had an agreement that you weren't aware of, the next step is, what can you do to try to resolve the thing quickly? So in my experience, there's usually roughly 4 types of ways, and there is some sort of modification within this on how these cases are resolved. So one way would be, hey, we find out this employee has a non-compete, we think it's enforceable, it's not something we were aware of before the employee was hired, we're just going to move forward with terminating them. And that typically, in 99% of the cases, is going to resolve it. Another option would be the companies get together and come up with some sort of a business solution that allows the employee to continue working. These cases, in my experience, often start off very emotionally charged, but then sort of drift into, hey, we're all just trying to do business here. This isn't moving the needle for either of us, and we're wasting money that we could both be using to compete against each other in the marketplace. So generally in these sort of cases, when it involves a sales employee, you end up with some sort of a list that the employee's walled off from, they can't contact for a certain period of time. And if that's something you as a company can live with, then that works and you reach a resolution on those terms. The other option would be the parties just go forward with litigation to determine whether the non-compete's enforceable. Again, for procedural reasons, the action and whether an agreement's enforceable comes early in the game. So then the parties are saying, hey, we're willing to commit the time and effort. This is important enough for us that we want to have a determination of whether this agreement is going to be enforceable and whether the person can work for us. The other option that I mentioned previously is the other company may elect not to pursue litigation. So whether that's when a cease and desist letter is actually sent, as in the scenario we posed here, or prior to a cease and desist letter being sent, it's not uncommon for companies to decide, hey, you know what, this person is a low-level salesperson, we're not concerned about him, so as a result, we're not going to push forward with some piece of litigation that we have no intent to go forward with. Usually, what I tell clients is that if you have good arguments and you decide you want to stand by an employee, unless there's an extremely high-level employee involved, CFO, VP of sales, something like that, you can often reach a compromise based on the restriction of customers. Because again, people really want salespeople to stay away from certain sales customers for a period of time, and everyone knows that if you haven't locked in a customer after a year or two, it probably wasn't long for the relationship anyway. So in most cases, that's a good way of getting the things wrapped. So that's a breakdown of what to do if one of your new employees generates a cease and desist letter. But what about the flip side of that? What if one of your employees leaves to join a competitor? So let's go through this scenario. We receive an email at 5 p.m. on Friday from a high-level engineer stating that the individual is leaving effective immediately. The engineer doesn't mention new employment, but you suspect the new employer is a competitor. And I've had this exact scenario. So what do we do then? Because here we've got somebody who's an engineer, they're high level, they're knowledgeable of our internal processes and you know the formula for Coke, so to speak, and what makes our company run. So step one is, what do the employees sign with your company? So the same sort of analysis of what are the agreements that this person may be subject to? Do they have a non-compete? Do they have a non-solicit? Do they have a non-disclosure? And also looking at when the agreement was signed. What becomes more difficult to enforce is if you have some sort of an agreement that was signed when somebody started working at your company in 1980, and here you are in 2019 trying to enforce it. Maybe the terms are off, maybe the description of responsibilities are off. That's a factor to consider in the analysis of what you can and can't do. And again, unless the agreement's clear, it's often advisable to bring in legal counsel, because what you want to do is say, hey, listen, here's the agreements we have, here's the information we have. So what do we think? Do we think we have a shot at obtaining enforcement in whatever we want to do? So in addition to reviewing the prior contracts, then you move to step two, and then you start the information gathering process. So as part of that, you want to talk to the employees, supervisors, and coworkers. And the sort of questions you ask at that stage is, was there any indication the individual was leaving? Do we have any idea that the individual was interviewing? Do we have any specific details about what was going on here? Now, this is a stage of the game here where I often see clients run into issues, because what happens is people form some sort of preconceived notion or after the fact notion of what this employee must have been doing. And a lot of speculation is used to fill in the gaps. So it could be, hey, yeah, you know, I noticed they took last Friday afternoon off, and, you know, that was the same day that his buddy from our competitor was in town. So it must have been that they were out having a beer and discussing what they were going to do here. And you get this situation where people are sort of trying to come up with a picture of the employee's activities after the fact. What you really need to do is get specifics and get into what do we actually know and what do we suspect and what do we think could be the case. Because you don't want to base whatever your decision is solely on things that you suspect or that you don't know. You're never going to be able to recreate a perfect picture of what the employee did in the weeks and months leading up to leading the company. But what you don't want to do is get a bunch of third-party, fourth-party, hearsay type information that's not something you can rely on, because you need concrete details to the fullest extent possible if you're going to actually go after people. And I've seen lots of instances where, upon further review, actions that look suspect in retrospect really aren't that suspect. So using that example, hey, you know, he must have been getting a beer with his buddy. Well, what if we get into depositions and we find out, hey, this key meeting that we think took place, actually, you know what, he was at his daughter's recital, so there's nothing there. And I've seen that play out in many instances. Or communications with a customer that's thought to be some sort of underhand communication may just be a communication that says, hey, I'm leaving, wish you best of luck. So making sure we drill down into details and get information is important, because operating on hearsay and information that's incomplete is not going to get us very far in a useful way in decision making in these cases. As part of this process, and I can't emphasize this enough, again, going back to our discussion about forensic analysis of electronic devices, sequester an employee's prior computer or phone. I've seen lots of clients in this exact scenario who reissue the computer to the workforce, and if they've wiped it, and what that does is that eliminates potentially really useful information. Because in most of the cases I've ever had where a computer was left sequestered and was not wiped or modified in some way, we've been able to extract really good data about the employee's activities in the weeks and months leading up to the termination, or their resignation, I should say, that were really successful in helping us enforce whatever agreements we had. So if you have an employee that leaves under suspicious circumstances, or if you have an employee that's leaving to join a competitor that you're aware of, don't reissue that laptop. Sequester it away so that potentially you can bring in an analyst to look at that device and determine what was going on. The sort of pieces of information that you can get from that are, for example, device history, device access history. So the IT consultants, what they can do is come in and say, hey, we know a flash drive is plugged in on, so the employee sent their resignation at 5 o'clock on Friday. We know that Friday morning at 10, an external hard drive was plugged in. We can't tell you exactly what was on it, but it looks like there was some activity. And we know that at 2, another USB drive was plugged in. And it creates a timeline that you say, okay, there's no business reason for this individual to be accessing devices. So there must have been some other reason for them to be plugging in and presumably downloading things in the hours prior to their resignation. Another thing that works a shocking amount of time is if you simply go and conduct a search within the employee's company email address for the employee's personal email or anyone else's personal Gmail. So you could search at Gmail, at Yahoo. Because oftentimes what happens is maybe the employee forwards documents to themselves in, a week prior to their resignation. Or maybe around the time that they would have been interviewing about a potential job, they email themselves some documents that they can review. And in multiple instances, I've seen that be effective because generally speaking, there's not a lot of reason that employees should be emailing their personal email with documents. So when you're doing your investigation, talk to people, sequester the laptop, and separately look through the employee's email account to see if there's any sort of suspicious activity within the email. So after you've gathered your information, you've reviewed the agreement, a very important step that people always skip is determine what your ultimate goal is. So before you put together a letter, before you decide you want to file a lawsuit, take some time, take a breath and say, well, what are we trying to accomplish here? Are we trying to prevent the employee from joining this new competitor? Okay, if that's the case, then maybe what we need to do is either send a letter or maybe just proceed with a lawsuit. Alternatively, is the goal just to protect the company's business information? Okay, if that's the case, then maybe we review, see what they've done with their laptop. If we don't have any indication they've stolen anything, we send a letter requiring them to certify that they have provided us all their company business information. What if the idea is to send a message to current employees? And I've seen this happen frequently where we say, listen, we've got a lot of people who may be sort of looking longingly at our competitor for potential jobs. People like this individual who just left. And so we need to ensure that that individual is able to recruit them. So maybe that makes us take a little bit more of an aggressive stance towards someone going to a competitor than we otherwise would have. Another potential goal could be we just want to protect our customer relationships. And while we don't want to lose this employee, their duties can be replaced by somebody else who's going to be comparable. And all we want to do is make sure that our customer relationships stay strong and they don't take them with us. Well, if that's the case, there's ways to do that. And maybe at that point, you're looking at negotiating out front some sort of resolution that is clear that the employee can't work with your customers or a certain subset of customers for a period of time. Your goals could be all of these things, they could be some of these things, or they could be none of these things, but these tend to be the primary objectives. And what you don't want to happen, though, is you find out an employee's joining a competitor. You do your background, you gather information, you say, well, let's just send a cease and desist letter and say that if we don't get certain assurances from you within 2 weeks, we're going to reevaluate our options. And then they blow off that letter. And then we say, hey, if we don't hear from you in a week, then we're going to have to file a lawsuit. And they blow off that letter. And then a week later, we're filing a lawsuit, because then you've backed yourselves into a lawsuit without doing the critical thinking of, hey, do we really need a lawsuit to obtain what our objectives are? Because lawsuits are expensive. They're definitely something that take a lot of time and effort, and it's hard to get damages in these sort of cases. Maybe all we really wanted them to do was to return a certain group of files that they had in their possession. And if you had gone for that more restricted goal, you'd have been able to save yourself a lot of time and money instead of sort of blindly following the path to litigation. So make sure if you do end up in this situation, you take your time to go and actually determine what your ultimate goal is before go into the next step. And the next step is aggressively pushing towards your goal. What I always tell clients in these sort of cases where you think an employee has gone to a competitor, time is absolutely of the essence. This is, you got to do the work to gather information, get data, get facts about what they've done, and determine what your goal is. That should be something that happens in a few-day period. And what you need to do from that point, though, is move forward as aggressively as you can on pursuing whatever those goals are. And if that's a cease and desist letter, that's fine. That letter just needs to be out within a week or so. If your goal is to get into court and request some injunctive relief, courts are going to expect you to be in within a couple weeks. You know, I've had situations where I've been in front of the judge and we requested injunctive relief and we're saying, Judge, we're really concerned they're going to harm our business. And the judge says, well, listen, I get your concerns, but you know, here it is 60 days since this employee has left. Why did it take you so long to get in front of me? And in those circumstances, you don't have a great answer. When you're pursuing these sort of remedies, when you're pursuing any of these goals, you want to be able to say, look, we take this so seriously that we were in front of you as quickly as we could have been. Now, I'm not saying that you want to get out in front of your skis. What I'm saying is you need to move forward fast to make sure that things are being protected. The other thing to do is if you're really concerned, in this case, we've got a high-level engineer going to a potential competitor and could be giving up some of our trade secret and confidential information. Well, if they do that, it's going to be very difficult for our competitor to unlearn that information. So we need to make sure that we're out in front of it and that we're able to stop it before that information is disclosed, because otherwise we're in a situation where, okay, maybe we reached a resolution that says they won't use it, but they still have that information, and there's no way that we can ever feel comfortable that that information is been taken out of their mind, so to speak. What are your potential options in these situations? Well, we've gone through a little bit of them. So one option that's obviously at the lower intensity end of the spectrum would be, hey, we have concerns. We reviewed this employee's device access history. We're going to bring the former employee in and say, look, we need to talk with you because we have indication that you engaged in some wrongdoing. And I've had clients do that successfully and, in fact, gotten the employee to sign something that says, yeah, I acknowledge that I took files I shouldn't have taken. I've returned all those, and we're good here. That's one way of, hey, we think that achieves our goals, and we're good, and we saved ourselves some time and money. Another option is, hey, we're going to put this cease and desist letter together. So we're going to go and say, all right, we're going to send a letter to you. We're going to send it to who we think is your new employer. We're going to put you on notice of our expectations of what you need to do, and we're going to put your new employer on notice of what your obligations to us are and what our concerns about your behavior are. And that has them looking at things in the same way we just talked about in the first section of this presentation, and it also puts the employee back on their heels. And a third option would be just moving forward with litigation. So, hey, listen, I've had it with clients before where we find evidence that a client has stolen thousands of individual files. They're going to a competitor. We have no confidence that a cease and desist letter is going to be honored and respected. So we just need to be in front of a judge. And so we moved forward that way. Whatever route you choose when you have this situation, the key is to be aggressive and to be time sensitive and to be pushing forward, because you don't want to be sitting on your hands and then later on having to explain that to a judge. So shifting gears here, the next scenario is what to do when labor organizing activity starts. So here's the scenario. So you work at a site that has no union presence. Let's say it's a manufacturing facility and they've never been unionized. However, you arrive to work one day and see picketers demonstrating in favor of unionizing the workforce. So what should you do? So the first step is to see what's going on out there and take a look at the picketing. So who is picketing is going to be a key question in these scenarios. Is the picketing somebody who just got off their shift and they're agitating for union involvement? Is it just some rabble-rouser from the local Teamsters operation who had some time to kill and decided that, for whatever reason, we think this company should be unionized, and I know that they're not unionized? Another question to ask is, are there specific issues being raised? So sometimes you'll just see people out there saying, hey, this place isn't unionized and it should be, some form of that complaint. Other times you may see more specific complaints, particularly if it's a current employee. So it could be, hey, we need fair wages, or hey, we need better hours, we need more employees. Whatever the specific issue is, the more specific the issue is, the more likely it is that whatever picketing is out there has gone beyond just a simple, hey, it's one person, into this is some sort of an articulation of grievances that have been discussed among our workforce. So the more specific the issues you see, the more likely it is that you should be concerned. Another question is, where are the picketers located? So if it's a non-company person that is on company premises, oftentimes we have an ability to say, hey, listen, you can't be on our property right now. That's not absolute, and that gets into some of the vague areas of labor law, but there is a lot of times where we're able to tell the picketer, hey, you need to go, you need to be off our property. Generally, though, the picketers are relatively savvy and know, hey, I should be on public ground. So maybe they're, on a public roadway across the street from you, and so we can't do anything about it. They're out there picketing us. There's nothing we can do about it because they have the First Amendment right to be out there. But looking at where they are, and are they blocking people's ability to enter the building? That's another way that we could potentially have them kicked off of our property. Those sorts of things are what you should initially look for. Just like we talked about with these non-compete scenarios, the step 2 would be gathering information. So talk to your supervisors to see if people know what's going on. And I've been out there in front of clients before where we went out there because there's this unexpected picketing going on. And we were out interviewing and discussing with supervisors, hey, what's going on? Were you guys aware of any potential organizing activity? And I've definitely seen multiple supervisors say, well, we had caught wind of it, but we didn't think it was a big deal. Yeah, I had heard a couple employees sort of rabble-rousing about how we should be a unionized facility, but we didn't report it up the food chain. So your supervisors are probably going to know more than you know. And the sort of thing to think about is, when did they hear about this? Who did they hear this from? How did they hear about this interest? So, again, looking at people that are sort of decision makers and leaders within your organization. So is it the one employee that no one really likes and is always being a pain for everybody who we heard talking about this? Okay, maybe our concern level is reduced. Or is it the one employee who's considered a leader among their peers, who's well respected and who can tend to bend the ear of people and be persuasive? Well, if that's the sort of individual who we've heard expressing a desire to unionize, that's the sort of concern we need to take more seriously. Going back to what we discussed, are there specific complaints that potential bargaining unit members share? So thinking about the group of employees that could potentially be unionized, do we know, hey, yeah, we've been getting employee complaints over the last month about their schedule and how they're always scheduled for overtime at the last minute. It's disrupting their personal life, and there needs to be some sort of seniority system so that they're not being forced into overtime all the time. Have we heard consistent complaints that, hey, we're not being paid at the same level that our competitors are paying their employees at, and they're making $18 an hour, and here we're stuck at $13 an hour? But what's important to understand, if you do get this sort of organizing activity, is that you cannot go to these non-supervisory employees, these potential bargaining unit employees, and ask them what's going on. What happens in that situation is that it's considered to be an interrogation of the employees, and we're considered to have chilled their ability to potentially organize. Labor law is pretty clear about this, and this is one of the things to understand and why it's important to have some idea of what you would do in the event that your non-unionized workplace has some organizing activity. That we're not allowed to, as management, go to potential bargaining unit employees and start asking them their feelings on unionization, asking them why they would unionize or anything like that. It's an important distinction to keep in mind. However, we can listen. We can always listen. We're just not allowed to do information gathering and go out and drill them with a bunch of questions. But if an employee comes to you and say, hey, look, yeah, I know those picketers are out there, and it's because Sarah's really upset that, her schedule keeps changing at the last minute. So, she called the Teamsters local and said, hey, we'd like you to come out and start protesting so that we can drum up some support for a union. An employee can volunteer that information to you and you can listen, but what you can't do is go to employees and seek out that sort of information. So that's why step 3 is important. So we talked about gathering information, but along with that, you want to have supervisor training if you get in this situation where there's potential organizing. So what is the supervisor training? So basically what that means is get all of your supervisors scheduled within a day or so, and because this is really something that, again, is time sensitive if you have this sort of activity, so that you can get them up to speed on what they are allowed to do and what they aren't allowed to do. So a lot of it's intuitive. And so, we talk about the TIPS rules about what you cannot do. So what you can't do is threaten, interrogate, promise, or spy, TIPS, T-I-P-S. So people understand, well, I can't threaten people about their union activities. So we can't go to somebody that we hear has, started to try to drum up favor in support of a union and say, hey, we're going to fire you if you don't stop that. I think that's pretty intuitive for most people that would likely be illegal. But what we talked about earlier, the interrogation piece of it, if we're just really trying to figure out what's going on, well, we can't use the potential bargaining unit members to figure out what's going on. We need to work through our supervisors. Similarly, we can't promise people things. And, it's in the idea of bribery. So we can't go to employees and say, hey, listen, if you start pushing back against unionization, then when the next supervisor role comes up, you're going to be the #1 candidate. We can't engage in that sort of behavior because it's the sort of thing that really gets us into a bad spot, and the labor board has determined that it's illegal to make those sort of promises. The other thing we can't do is spy. So we can't, if we hear employees are going to the bar down the road to have a meeting about whether they should organize, we can't just sort of all of a sudden show up to overhear what they're saying. That's, again, something the board is considered illegal. And why this stuff is important for your supervisors to know is because if they take the wrong step, if they violate these TIPS rules, if there is an election to bring in the union, what could happen is the board could say, well, I know you, employer, were successful and won the election, and so there isn't going to be a union here, but you guys violated these rules, so as a result, we're actually just going to determine that a no fair election was possible and a union's in there anyway. So by violating these TIPS rules and not knowing about them, your supervisors could inadvertently be the cause of a union coming in, even if the union lost the election. It also allows us to tell the supervisors what they can do, and they can give facts, opinions, and examples. So the idea is, hey, I can talk about what it would cost to be in a union and what your monthly dues are. And I can talk about my opinion and the company's position on unionizing. And I can give examples of what's happened to our competitors that have unionized. But what I can't do is say, oh, in my opinion, you'll be fired if you join a union. Well, that's a threat wrapped up in a promise or an opinion. So letting supervisors know what they can and can't say is important, and this sort of training is key. And again, during these trainings, we can go back to that fact gathering part of things and talk to our supervisors about, hey, what do you know? What's been going on out here? What have you heard? So after we've conducted supervisor training, the next step is develop messaging. So when we're looking at messaging against the campaign to unionize a facility, it's important that we identify well-respected supervisors and key human resources representatives to be part of the messaging team. What you want is people who actually understand the concerns of employees and are actually familiar with what is going on in their lives and what issues they may have. You don't want the people who are maybe the pure yes people that don't really, or maybe they don't, it's not that somebody needs to decide with the employees who potentially unionize. What you need to know is what is really going on with their lives. What's really the sort of things that are causing them issues. And if you have the wrong people in the room, you're going to develop useless messaging because it's not going to be helpful to the end result of keeping the union out. One of the things to understand as part of this messaging process is that the financial cost of unionizing to employees is always a key component of messaging. So as you would develop messaging, if your company decides, hey, we don't want our facility to be unionized, we want to run a campaign against this, it's just in the same way the union's running a campaign against us. One of the things that is always cited is, hey, this is what your union dues are going to be. So in order for you to get some sort of financial gain off that, you're going to need to obtain concessions above and beyond 3% of your pay or whatever that number is. That's always a key component of the messaging that's worked in. The next step during a campaign is to hold what are called captive audience meetings. So you've gone through, you've gathered information, you've talked to your supervisors, you've trained them, and you understand what the issues are that the employees have, and you've developed messaging that addresses those issues. So then you hold these meetings with employees and say, okay, here is what we as a company view, here's the things that we do, here's what we've been trying to do to help you all, and here's our position on everything. These captive audience meetings are really the company's time to put out their message. And as a company, we are allowed to have these sort of meetings where we give ourselves the opportunity to go through and describe to employees our position, what the company has done over the years to benefit its employees. So let's say, for example, we find out that the employees are complaining because their view is that our competitors are paying people $5 an hour more than what we're willing to pay. Well, presumably there's some sort of a rationale for why we approach things that way. Maybe that rationale is actually, the competitor isn't really paying $5 an hour more. Here's all the other ways where you're compensated similarly. Maybe we offer a much better health plan than the competitor does. And so there's no real actual financial difference. Whatever the rationale is for how we've done that, that's our chance to tell the employees that. The other thing is that we would continue on a regular basis to have these meetings as necessary in order to inform employees about the company's position. The union really has access to employees at all times during non-working hours, so this gives us our chance to have access and explain our side of things to employees during working hours if we decide, hey, we really don't want to have a union in the facility, and here's our rationale for that. So the final scenario that we have is what to do when an employee complains about a high-level manager. So, particularly with everything that's going on in the news, I think we're all familiar with this sort of scenario. An employee walks into your office and shuts the door. The employee tells you that the VP of the employee's business unit has sent unwanted text messages and made sexual advances at off-site conferences. The employee says they don't want to make a fuss and is concerned about retaliation. The VP of the business unit outranks you and is well respected within the company. So this is sort of a nightmare scenario for an HR professional. And so the question is, how do we handle it? So step one, just with any other sort of complaint that we would get, is you document it. So you want to remain empathetic to the employee because in any of these scenarios, particularly these of a sexual harassment nature, you want the employee to understand that you're not prejudging the result and that you're not coming out in favor of the company without having done any sort of investigation, but that you do need additional details. So you want to gather as much detailed and specific pieces of information as you can. So if the employee claims that they've received harassing text messages, you can ask to see those text messages. You can take screenshots of those text messages. Another item you want to do is talk about dates, times, locations. Okay, what off-site conference? Who was there? What did you raise this concern before? All those sorts of things that you would do in a normal procedure, but here the level of intensity is going to be heightened because you understand that, hey, we're dealing with a high-ranking employee, who has been allegedly engaged in this conduct. There's going to be a lot of eyes on this scenario. So I'm going to be out in front of my documentation. One thing I always encourage people to do when they keep notes of a discussion is have your name on it somewhere and date that discussion. What you don't want to have is months down the road, there be some dispute over, well, no, I went in and complained to Sally on September 19th. Well, no, you actually complained to me on October 5th. Allowing yourself, date the document, sign the document so it's clear when the complaint was raised to you, so that you're starting to build the timeline of what the company did to investigate that from there. You also want to inform the employees that complaints like this are serious and that you need to be ensured that an appropriate investigation is conducted. As I'm sure most of us on this call are familiar with, if an employee comes and says, hey, listen, I don't want to make a fuss here, I just need to get this off my chest. Well, we can't not investigate that. You need to move forward, you need to investigate, you have a legal obligation at that point. And I think it's important to share that with an employee, particularly if you're in a situation like this where you have someone so high ranking that you need to figure out, hey, listen, I understand your concern, you won't be retaliated against, but you need to understand that we have to follow these procedures here. We need to make sure that this is investigated. So after the complaint has been documented, what do you do next? Well, what I would advise in a situation like this is carefully take a look at your policies and procedures with respect to investigating reports of harassment. This sort of a situation, again, is something that's ripe for litigation, whether from the VP side of things or from the employee side of things. So you need to make sure that, hey, we have this objective policy in place. These are the steps that the policy calls for. So these are the steps that we're going to take. What you also should do is think about things internally. So if you're in a large organization and you're subordinate to this VP, you need to make sure that the investigation is protected. So that could be notifying your direct supervisor about what's going on. If there's a general counsel, working with your direct supervisor and the general counsel. But make sure that within the organization, while still keeping things confidential and to sort of an appropriate group of employees, that you're working within the food chain to identify how can we make sure this investigation is done neutrally, objectively, and independently, and not done in a way that someone who's several layers up in the company is ultimately going to disregard or squash. Getting out in front of that particular issue is important so that you're able to ensure that the investigation can take place in the way it needs to. As part of that process, once you've figured out, okay, so I've talked to my direct report, we've involved the VP of HR, or I talked to my direct report, and my direct report's the VP of HR, so we feel comfortable. Then you analyze the workforce that you have and say, okay, here's what our policies and procedure call for in a typical case. So in a typical case, I would be responsible for conducting the investigation. Am I somebody that has the skill set, experience, and background to conduct an investigation at this high of a level? If the answer is yes, okay, great, then you can conduct the investigation, or the appropriate person according to the policy conduct the investigation. However, it's important to be realistic and candid in your assessment of the situation, because it very well may be that you decide, you know what, we don't have it, this is the first time we've ever received a complaint like this. This is beyond anything I've ever done. I don't want to dabble in something. I think we need to get a third-party investigator to come in. We need someone who's objective, who's neutral, and that we can point to, hey, this person isn't conflicted out for some reason or another. There's no sort of moral or ethical reason that they're not able to conduct a completely clean and independent investigation. You should understand there are definitely attorneys that do this sort of investigation, but in all likelihood, the investigation that's conducted is not going to be something that's covered by attorney-client privilege. So if you hire a third-party investigator, you're bringing someone in who's going to be subject to cross-examination, and their report is going to be subject to analysis. And that's frankly part of the reason why you want to bring a third-party investigator in, because you're hiring them to do a report, to do something thorough so that your position is defensible. So in addition to just making sure the allegations of the complaint are being addressed to the fullest, you're also analyzing this as something where, okay, we want to make sure the employee is protected. We want to make sure our other employees are protected from this potential conduct, but we also want to make sure that the company is protected and that we're doing a defensible, justifiable investigation. And a third-party investigator can be a big help in that. If, again, you don't feel as though the company has somebody within ranks who's able to do it independently. The next step is to conduct the investigation. So whether it's you, somebody else, or a third-party investigator, make sure the investigators have been provided access to the key individuals. So the key in these sort of situations, and where a claimant and person who's filed the complaint starts to get nervous, is if they feel as though the investigation has been swept under the rug and the complaint has been swept under the rug. So you need to make sure that you're doing things thoroughly. Again, you don't need to involve everybody in the company. You don't need to go beyond a scope of what's reasonable. But what you want to make sure is that when you're talking to somebody, it's not, oh, I talked to that person for 5 minutes and I think we're good. I don't think we need anything further. You need to be talking to the key people. You need to give yourself enough time to talk to the key people. And you need to make sure that you're asking all the questions that are being posed. As part of this, you want to engage with the individual who's lodged the complaint. Certainly, you'll need to come back to them and get additional details and verify their side of the story. But you also need to understand that the longer the process drags on, the more that individual doesn't have communication with anyone from the company, the more they're going to feel as though they've been isolated and that they're being left out in the wind. And when they feel that way, that's what's going to prompt them to start looking for a third party who can come in and help them. And then you start introducing them having an attorney into the process. And that attorney, frankly, has a profit motive. That attorney doesn't have a motive necessarily of fully protecting the individual. That attorney doesn't have a motive of protecting the company. Their motive is to obtain some sort of profit off the situation because they're a hired vendor. So if you leave the employee hanging out there without any communication, that's the sort of thing that can happen. And again, in this scenario we posed, the manager, the VP, had allegedly sent illicit text messages of some sort. So if that's the case, you need to make sure that any text messages have been retained. So there's something called the document preservation letter. This may be a situation when it's at this level with this serious allegation against a high-ranking employee where you have to send a letter to that individual and say, hey, you need to preserve both that individual and the complaining party that says you need to preserve any documents or text messages or emails that you may have that's relevant to this complaint. Then step 5, you conducted your investigation, you've made sure that information was retained. What do you do next? Well, once you've gathered everything, take a look at the facts that you have in the context of the company's policies, the guiding principles of the company, and prior experiences of similar, if any, reports. Don't allow the short-term hurdles to overtake the decision-making process. So it's a short-term burden for the company to terminate somebody who is well-respected and on their way up within the company, if that's the way that the investigation shakes out. But just because that's going to create a short-term business concern does not mean the right decision is to only give that person a slap on the wrist if your policies, the guiding principles of your company, and your prior experience dictate that that person be fired. Because then all you've done is create a short-term relief from a problem into a long-term problem, because you're likely to get some sort of litigation. And the individuals who engage in this sort of behavior are likely to do so on a recurring basis. So if you go light on discipline that's not supported by policies or procedure, you could not only generate a lawsuit from the individual who filed the complaint, you could be looking at a lawsuit 5 years from now based on similar conduct. And then not only did you have the issue of that conduct recurring, but you've also got the company having knowledge of that and retaining this. And that creates a separate cause for liability. So it's important to have the guts that if your decision is led in a certain direction by your guiding principles, prior experience, and policies, then you follow through with that. At this point, even if you have a third-party investigator, but if you've done the investigation yourself, regardless, consult with someone that you can have a conversation with on an attorney-client privilege to evaluate your risks. So what are we looking at? Does the VP have a contract? What does that contract say? Does this individual have a claim? Is there really nothing to support these allegations and there was nothing unprofessional in any way that was found? And what sort of claim does that create? Evaluate all these risks based on the results of your investigation so that you're in a position to reach the right conclusion. Before you make your decision, understand what that employee is looking. Maybe the complaining employee says, hey, these texts were things I found to be inappropriate. You look at the text message and you decide, well, maybe they don't pass the would my spouse be okay with it sort of test, but they're not inappropriate at the level that we think merits termination. So understand what the employee's goal is. Does she want this VP fired come hell or high water? Does the individual want the VP to just be moved out of a new business unit? Does the individual want to just move on and work at a different company and want some sort of severance package? Understand what the goal is, and that may help you in reaching that final decision. And then finally, you want to make a reasoned, supportive decision and then stand by it. You don't want to waffle on your decision. And in order to do this, make sure that key stakeholders are involved so that the decision isn't a surprise. So if the VP of the business unit was in line to be the next CFO of the company, and they were the protege of that CFO, reach your decision independent, and then maybe give the CFO a heads up on what information they need to understand. Because you don't want high-level people to be blindsided by a decision, because if that occurs, then you're going to end up with another issue on your hand, and they may try to work to unwind the decision without having any understanding of the severity of it. So that concludes our final scenario here. I guess at this point, I'll leave it open if anyone has questions. I appreciate you attending and hope that it was a good use of everyone's time.
We do have one question.
Sure.
Would your ultimate recommendation be to bring a third-party investigator in most investigations then, or only in extreme situations?
So I guess my answer depends on how qualified and skilled your HR team is. If you have a good HR team, my recommendation is to only bring in a third-party investigator in extreme situations. And that would be, the HR team is conflicted for some reason. It could even be that the investigation needs to be conducted within the HR department. In that case, you would want to bring in a third-party investigator. Here, though, if you have a scenario where your team is maybe more on the range of HR generalists that aren't familiar with investigations of this sort of sensitivity, maybe their involvement is more, they're working on processing FMLA paperwork, or maybe their involvement is more in managing relations under the CBA if there's a unionized setting. At that point, you may need to consider bringing in a third-party investigator more frequently, because ultimately the goal is just to make sure you have someone who's a qualified professional conducting the investigation to make sure it's being done properly.
Awesome. And that concludes the webinar. So I just wanted to thank Steve for that awesome presentation and taking the time to do that for us. So have a great day, everyone. And if you have any questions, just email me at anna@hrsimple.com. Thank you.